Here's an interesting video.
We're back on the record, CR 2020-136-173-001, State VS Hasz. Counsel for the court is present, defendant is present. The witness is still on the stand. Defense cross.
Thank you. Good afternoon, Mr. Delgado.
Good afternoon.
I'm Martin Bihn. I represent Mark Hasz in this case.
Nice to meet you.
I want to be clear about what you're not offering an opinion on. You are not offering an opinion that Mark Hasz violated ARS 13-1203, the assault statute, right?
That is correct.
You are also not offering an opinion that ARS 13-403 justification, subsection 2, does not apply to Mr. Hasz, right?
That is correct.
Your opinions here today, in large part, were based on Graham versus Connor, right?
That is correct.
You were referencing Graham versus Connor and 4 standards that you were applying, right?
That is correct.
And Graham versus Connor was a civil case, correct?
That is correct.
And Graham versus Connor was a civil case that pertained to liability under 1983, section 1983, right?
That is correct.
So what you're looking at and what you testified about was standards of civil liability for 1983 violations, right?
That is correct.
We're not here about a civil 1983 violation, are we?
No, we're not.
Do you have an opinion as to the interplay between a civil rights violation and a criminal law violation? That is to say, does one necessarily mean you violated the other?
The Graham v. Connor case basically became the standard through the Supreme Court to view how use of force is objectively reasonable by a reasonable officer. Those factors have taken place to assure that when dealing with use of forces all across, when it comes to with law enforcement, those are the standards that we view that use of force standard by.
Right. For civil liability under 42 U.S.C. 1983, right?
That's correct.
You have not offered an opinion that the Graham versus Connor elements, if they're met, suddenly create a criminal violation, right?
Not today, yes, that's correct.
So I want to go back a little bit on what you based your opinions on, okay?
That's correct. Okay.
So I understand you saw the video, right?
That's correct.
And you had the IR reports or the SIR reports.
That is correct.
And then did you have the criminal CIU investigation?
Yes, I did have those also.
Did you have the transcripts of the CIU investigation interviews of the inmates and the officers?
Yes, I did.
Did you review those?
Yes, I did.
Do you recall then in Mr. Peralta's, any statements Mr. Peralta made in his interviews about what Lieutenant Hasz told him when they were up against the wall?
I don't recall in detail exactly what he was saying in the reports.
Well, this would be in the transcript.
Transcripts, yes.
Okay. Did you receive the transcripts from the prior trial in this matter?
No, I just received them before this becoming here.
I agree, but I want to ask you that there was a prior trial in this case.
Okay.
You aware of that?
Vaguely. I knew there was one, but I didn't know the extent of it, yes.
What I'm asking is if you reviewed any transcripts that might have been made of that trial.
Oh, no, I did not.
Did you review any transcripts that might have been made of the inmates who testified in this case?
No, I did not.
Were you present on teams when the inmates testified in this case?
No, I didn't. No, I was not.
Were you present when Mr. Pruitt testified in this case?
No, I was not.
Do you know Detective Pruitt?
Yes, I do. I know who that is.
How do you know him?
I used to work when I was at Pinal County Sheriff's Office. I used to work for a gang unit, and I knew Pruitt from then when I used to, through networking and through Arizona Gang Investigators Association.
Are you presently co-workers at the Department of Corrections?
I work in a different area.
Right.
He works, yes, but I work for the department. That is correct.
You do training, right?
I do training. That is correct.
And I can't recall what he does. Do you know?
I think he works in an investigative unit.
And so you didn't review any of his testimony before coming
No, I
here?
do not.
So you wouldn't know if Mr. Pruitt found the takedown to be appropriate and fine?
No, I would not.
You wouldn't know if Mr. Pruitt had no problems with any of Mr. Haasz's actions until the takedown?
Yeah, that's correct.
You talked a lot in your direct testimony about body language. And I'm wanting to know, do you have any formal training in analyzing body language from any school or university?
Body language. When it comes to training with body language, the only body language I have is through reads, interviewing, and interrogation type tactics. You read through people as you're interviewing their body gestures of how they're doing, basically how they're, as you're interviewing them, how their demeanor is, what kind of body gestures they're making. Are they slouching? Are they applying any type of deception? But that's the extent of my training to reading body language.
You've been trained in reads, which isn't that an analysis of an interviewee's physical responses to your questions?
That is correct.
You weren't asking any questions of Mr. Holland in this case, right?
No, I was not.
Did you read the transcript of his interview by CIU?
Yes, I did. As I was reviewing it, I tried to cross-reference to what he also put on his SIR.
Did you make any notes?
No, I did not.
And when did you do this analysis? Because there were a lot of documents, weren't there?
There were a lot of documents. That is correct.
I mean, it's not a one-day reading, is it?
Oh, no way.
So when did you start preparing?
A little bit over a month ago.
And when did you reach your conclusions or your opinions?
It took me a few weeks because I was away during a time when I was reviewing the works in San Diego, going through another training. And I'm just trying to review every aspect I can of the incidents occurred and try to cross-reference what the officer at that point was trying to see the incident as from that person's perspective. And the more I reviewed and read the report based off those circumstances, I had to look at how is it relevant to why the force was applied. After reviewing it several times and reviewing the videos, slowing it down, trying to view it to see where those actions took place, I could not find any relevance to it, and that's when I came to my opinion.
And when was that? Like last week, 2 weeks ago, yesterday?
2 weeks ago.
That was before you listened to today's testimony, right?
That is correct.
And that's before you listened to yesterday's testimony.
That is correct.
And nothing in the testimony you heard yesterday or today changed your opinions, right?
No.
Am I correct?
That's correct.
Did you, in your review, discover when, well, let me ask you this. Do you know what an ICS is?
Yes, I do.
Did you, in your review, discover when the ICS was called?
It's hard to say because there's no sound, so you can't determine when exactly it was called. You can only base it off reports, and reports doesn't give you a time when the time it was actually called. But no, a report say it was called, but if there's no sound, you can't hear it being called over the radio.
Based on the body language, could you tell when the ICS was called?
Body language, it looked, based off the body language, it wasn't called until additional resources started to arrive on scene. Usually, when an ICS is called, it takes a few minutes, depending what location it's at and how much staff you have, about resources to arrive on scene. The takedown happened, and then it took about a few, maybe, less than a minute before additional resources started to get there to assist.
Okay, let me ask that again, because I'm not sure that was responsive. Could you tell by the body language of the officers involved when the ICS was called?
You can and cannot. What I mean by that is this. You can tell if there is an emergency situation, you can tell how everyone responds. And then when there's not call, you can tell how something is not, if things are the same. So to answer your question, you really cannot identify exactly when it was called.
So you can't tell by body language when it was called,
No.
right? Okay. Do you know who called the ICS?
Based off reports, it seemed like it was the person in the control room.
But you don't have any information, or do you, about the person in the control room?
No, it was a very brief report.
Did you read the interview transcript of the person in the control room?
That I did not.
If the person in the control room was named Santana, would that
That's
help
true.
you?
Yeah, I remember that name because it was on the initial report where it was really like a 2-sentence report showing that it was involved but in the incident by calling ICS.
Did you receive copies of the transcripts of the defense interviews of the witnesses in this case?
No, I did not.
So you didn't read a defense interview of Ms. Santana?
No, I did not.
Did you read the transcript of the CIU interview of Ms. Santana?
No, I did not.
So really, your information about Officer Santana was what you saw on what she wrote on the ICS report.
Correct.
Sitting here today, do you have any recollection of that?
Just that there was that one simple, like, really brief report that she wrote.
Yeah, but you don't remember what it said. You got a picture.
No. I don't remember verbatim what it said.
So, had she, for example, written something hypothetically that she activated ICS, when she saw Peralta pull away during the escort, would that mean anything to you and change your opinions?
No, it would not.
Okay. And I understand you've got a post-certification in, I forgot, what was post-certification in?
Defensive tactics?
You're not a post-certified peace officer, correct?
That is correct.
And your career has been through the detention side, largely, of the Pinal County Sheriff's Office.
That is correct.
And when you were talking about investigations and reviews that you were doing in the capacity of a lieutenant at the Pinal County Sheriff's Office, were you talking about investigations in the jail or throughout the department?
It was all specifically in the jail.
In the jail. So you weren't applying Graham factors to police officer use of force?
No.
Or, deputy use of force?
No, I was not.
You heard a number of questions to the expert about the difference, our expert, the difference between a county and a prison jail.
That is correct.
What are the differences you might identify?
The difference between a county jail and a prison falls under the 8th Amendment and a cruel and unusual punishment, which also the factors do apply on that one is, I believe, Hudson versus McMillan. That was the most case that when it deals with cruel and unusual punishment that doesn't have to require excessive amount of injury to a subject, opposed to a jail, which I can't remember exact law that goes, but it is different. It's separated in 2015 of how to treat jail inmates.
You're talking under Section 1983, correct?
For which one?
For 8th Amendment violations.
Yes.
Isn't the difference that a county jail has both detainees who have not been found guilty and also people who've been found guilty and are doing a sentence?
That's correct.
Prison, you only have people who've been found guilty.
Correct.
And those standards you just mentioned, the 8th Amendment standards, those again are standards for civil rights cases, right?
That is correct.
Has nothing to do with criminal liability.
No.
I may have missed part of your testimony, but did you testify about force isn't justified if the inmate is just using words? Something to that effect?
So when an inmate's verbalization of saying things to you, force that we apply will not take that into consideration unless the inmate is showing reactionary attempts during that process.
Okay. Let me just ask you, do you believe this is an accurate statement that prison officials have the right to use force whenever necessary to maintain order, and that necessity may arise when only words, not including a threat to use force, have been spoken?
Yes.
That's valid.
Yes, that is valid.
Is that different than what you were testifying to earlier?
No. What I'm testifying is that when you're as a correctional professional, you don't have to use those verbs and take them into consideration to make a decision on what type of force you're using.
Okay. Do you know, and if you don't, that's fine, do you know under Arizona law if it's permissible for a corrections official to use force on an inmate in response to simply words that don't include a threat?
Yes, I do know that.
And is that appropriate?
Yes, that is.
Okay. I have no further
Video.
questions.
So the guy you see there is our defense attorney. That was Martin Bihn, who'd been patiently waiting for 4 years just to get up and just start nuking these people, just the way you saw there. And Martin asks him, our lawyer asks him, did you review the testimony? He says, no, I did. You guys saw it. No, I did not. So you wouldn't know if Mr. Pruitt found the takedown for that was the prior use of force. He goes, no, I would not know. This is a use of force expert, not knowing anything. He goes, you talked a lot in your direct testimony, a lot. That's his way of saying 75 to 80% about body language. And I'm wanting to know, do you have any formal training in analyzing body language from any school or university? That was a hidden joke from him. Insulting, because there's no such thing. He just wanted that. So he throws it out. Here's the expert witness. Body language, when it comes to training with body language, the only body language I have is through reads, interviewing, and interrogation type tactics. Just so you guys know what reads is, because I don't even know if you guys know. It's an amateur thing people say when they want to come across like they're an expert in body language. They go reads and tells, like he's some kind of card player. Complete amateur, right? So that's what he says. Through reads, through body gestures of how they're doing, basically how they're, as you're interviewing them, how their demeanor is, what kind of body gestures are making, are they slouching, amateur shit, are they applying any type of deceptions, but that's the extent of my training of reading body language. 75 to 80% was based on that bullshit statement he just made there.
In a one-on-one direct interview, feet away, yet this video on a fisheye camera is 30 feet away and he's reading body language. Crazy.
Yeah, in an interview, it's a use of force. It's a ICS situation.
Right.
Based on the body language, could you tell when the ICS was called? This is what our attorney asked him. He goes, body language? It looked based on the body language. It wasn't called until additional resources starting to arrive on the scene. Usually when an ICS is called, it takes a few minutes depending on the location and how much staff you have, about resources, above. The takedown happened, and then it took about a few people, maybe don't know, less than a minute before additional sources got out there. He goes, let me ask you again, because he's rambling on, because I'm not sure if that was the response, right? Could you tell me, can you tell by the body language of the officers involved when the ICS was called? You can and cannot. This is what he responds with. You guys better watch yourselves. That is a dangerous thing to say. So you can and you can't. It's like being half pregnant.
Yeah, you can get time in prison because this guy's in there lying
Yeah,
and blowing smoke.
because of people like him. Absolutely. Ooh, this turned off. Hold on.
And let me be clear with you real quick. The ICS was admittedly called, the prosecutors and us was called by Santana in the control room during the escort, before the inmate even got to the wall, for an aggressive inmate.
Yep.
So the minute he started to pull, The minute, right after I put him in the cuffs, she called the ICS. We had help on the way. So yeah, we didn't call the ICS because she was already calling it from the control room.
And, as we just said, to reiterate, prosecution says it happened. We says it happened. Everybody agrees that it happened. This guy.
Camarada agreed. Yeah, Camarada at the time of charging this case didn't know what an ICS was. That's interesting. That's key information about trying to identify an aggressive inmate, right? The people on site identify an emergency, but you don't want to take their word for it?
Yeah.
Maybe a battery as well.
I want to show one more video and then we're going to do a free talk, okay? One more video.
So consistent with other witnesses, I'm going to have some questions for you. We have observed this process this morning with the defense expert. Then we'll go back to the defense to ask some follow-up if they have any, and the state will have the last opportunity to ask you questions.
Yes, Your Honor.
So, I'm sorry, let me go back to some of your experience. I had a couple questions here. You seem to generally outline some detention officer, maybe the term is correction officer duties in a corrections environment with Arizona.
That is correct, Your Honor.
And how many years did you do that type of work?
I've been in corrections for going on 22 years.
But in terms of correction officer duties where you would have regular contact with the inmates, how long did you do that?
18 years.
And did that involve you at times needing to move or transport inmates in the corrections environment?
Yes, it does, Your Honor.
And did you ever move or transport inmates that in handcuffs?
Yes, Your Honor.
Did you ever move or transport inmates that were resistant to being moved?
Yes, I have, Your Honor.
Did you at any time ever take down what we've kind of generally referred to as a takedown, something similar from a standing position to the ground, an inmate in a correctional facility?
Yes, I have, Your Honor, but not restrained.
All right, so let's go ahead and go to that point. I have some questions on that. You seem to testify that there would have been no method of taking a restrained inmate to the ground trained under any of the Arizona training protocols.
That is correct, Your Honor.
Is it also your testimony that there was never, even if you say that training would not have happened under your understanding of the training, are you saying there would be no circumstance where it would be appropriate to take a restrained inmate to the ground?
Not when they're not resisting, Your Honor.
Okay. So there could be some circumstances.
Yes, that is true, Your Honor.
Well, so then I guess my follow-up is if that is conceivable, why would there not be any training in how to perform that type of takedown? If you know.
Well, I can only speak for currently where my previous departments and now at Arizona Department of Corrections. When it comes to takedowns, there's other methods to secure an inmate when they're restrained and they're not compliant. The most effective way that we found over the years is when someone's restrained from behind is to sit them on the ground to avoid any injury, because an inmate cannot brace himself or defend himself when he's cuffed and restrained from behind.
Okay. And I understand there may be alternatives, but I guess at the end of it, I'm just asking, could you reasonably conceive of a circumstance where it may be appropriate to take a restrained handcuffed inmate to the ground?
Yes, Your Honor.
And I think, because I was going to come back and ask you a question, because you were asked by the state your ultimate conclusion, and I found it interesting the way you stated it, that the takedown was unreasonable and there was no reason to take a handcuffed inmate to the ground, but you didn't stop. The sentence didn't end there with a period. It continued because there was no active resistance, I think is what you said.
That is correct, Your Honor.
Okay, so that is, I guess, an acknowledgement that there could be a circumstance where it would be appropriate to take a restrained inmate to the ground.
That is correct, Your Honor.
And even through this discussion now, you would still testify that you are not aware of any method that would be trained in an officer in how to do that.
That is correct.
Is it possible, because you have some familiarity, I don't want you to speculate, But is it possible that there is training that goes on at locations or in other venues or circumstances that you may not be aware of that may discuss that?
There could be possible trainings that would, but not authorized by the department.
Okay, fair enough. You say that you've done reviews or been involved in investigations or reviews of use of force?
Yes, Your Honor.
And I think we got some of this already, but do you acknowledge that there could be a difference between a set of circumstances that is deemed to be a violation of policy, but would not necessarily constitute a criminal offense?
There are certain circumstances with that, Your Honor.
Did you review any information in preparing your opinions for this case? And I'll tell you, I suspect this might have been if you received some type of reports or statements from either defendant or Mr. Holland, that there was some resistance from inmate Peralta either or during the escort or at the wall. Did you receive reports giving that version of events?
Yes, I did.
It seems in you reaching your conclusion, you determined that that version or those versions were not consistent with other information you received.
Yes, that's correct, Your Honor.
And was part of that your assessment that those versions were not consistent with what you saw on the video?
That is correct.
Anything else in particular in your review of whatever you got to see in this case that caused you to find that version of events was not consistent?
Yes, the incident report, the SI reports from the lieutenant does not match what the show is in the video. On his incident report or the SI report, it says that he began to pull away.
Right, so I got the video.
Oh, yeah.
You say that doesn't match the video. Is there anything else in what you reviewed?
No, Your Honor.
So it's primarily your review of the video.
Correct.
Now, let's say that on review of the video, that you were able to discern bigger movements from inmate Peralta, either during the escort or at the wall. I'm kind of changing it. It's hypothetical.
Yes, if there were bigger movements demonstrating that he's resisting the hold that the officer or lieutenant is doing, it does play a factor on a different type of outcome.
Okay. In any of the statements that you reviewed from Hasz or Holland, did they indicate a belief that Peralta may be trying to slip his cuffs or slip away from Hasz? Not just resistance, like I'm walking and leaning, but actually slip away.
Yes, on the reports it does say that.
So I guess I'm trying to reconcile, as a person that's coming in and reviewing this, what kind of weight do you give to the statements of the people that are there actually experiencing things versus you looking through a fisheye camera at 2 or 3 minutes of a video? How do you reconcile those things in your work?
When I look at how consistent it is with the video, by the statements that are made when someone says actively they're pulling away from me or they are twisting and turning. I'm looking for those type of movements to determine if those are what legitimately is happening. So when I look at those things, I try to find everything I can from the perspective of that officer of why that decision was made. When none of them are visible, and based off of what I've seen, the facts of the incident report and the video, that is how I perceive my opinion on what did occur at that time.
Did you, in reaching your opinions, factor in the nature of the video, the fact that it's that camera from a single view without any audio? Did that factor into your analysis of assessing what the officer said happened versus what you believed you were seeing?
It did. That's why it took me some time to come to an opinion on it. I try to see it from any perspective I can, based off what is documented and articulated, and I still came up with the same opinion when it came down to the final opinion of the incident.
All right, thank you.
Okay, so what you saw there at the end, the judge, we already knew the judge was looking at this expert witness already. He had doubts in his mind. So he starts asking his own questions. This is the judge saying, now I got questions for you. Because Delgado said that he had looked and couldn't find any uses of force that way. And you got, that training didn't exist. He just, thousands of them, they picked you to be the one that they picked, right? So the judge himself asked him, is it possible, because you have some familiarity, I don't want you to speculate, but is it possible that there is training that goes on at locations or in other venues or circumstances that you may not be aware of that may discuss that? He says there could be possible trainings that would, but not authorized by the department.
That's dangerous.
You guys are in shit. I'm telling you, whatever they want to do with this guy here, whatever he wants to do with you, he will do. We've all been trained in use of force, taking down inmates. Hell, I taught SMU 1, that's the first thing they teach you. Here's the best way to take inmates down. This came down from all the way to top. This guy couldn't find one shred. Thousands, and I got over 500 videos showing this douchebag
doing single-handed escorts,
yes,
not double locking,
but Delgado didn't know that. And Delgado didn't know we had the 550 videos.
and putting inmates down on restraints.
Yeah.
Numerous.
So is Delgado saying that briefing training is unauthorized?
Apparently so, yes. And that double locking, if you don't double lock, you're screwed. And you have to give them time to air out. I know you want to bring that up, where words are not enough. You have to give them a cool down period and all this other shit that he brought up. Yes.
Yeah, cool down periods, as everybody knows, is for a planned use of force.
Correct.
A reactionary, spontaneous use of force, there's no cool down period. You can't just pause life. Like, hold on, pause, Hasz, halfway down. Okay, we're going to sit here in the middle of the air for a few minutes and cool down. That's not how it works.
Correct.
Cool down periods are for pre-planned. Also, during his testimony, he said it was appropriate that staff can use force based on words without a perceived physical threat, because that's what the law says. That's what Supreme Court ruling says. He's telling you all, don't use force because of verbal statements, but then he's turning around and saying it is appropriate for you to do so.
Yeah.
This is dangerous for all corrections because he's sending mixed signals, he's teaching wrong things, and he's setting up all of the officers and the department and the inmates families, and the entire state up for failure, up for litigation, and someone's going to get killed.
He contradicts state law specifically with all of that. The law states that we don't even need a verbal threat to use force. We just need to be able to prove that we need to preserve the peace.
Who knows this better than AZCPOA? I don't want to go on, let's not go on this trip on ACA and FOP, but their members come running to us. I'm saying it here on video.
Absolutely.
Their members come running
Daily.
to us daily because they can't get help over there. So I don't even know why they even come to us, because I can't help them per law. I mean, we have our members, they're the ones that pay, we help them. But what was I going to say? I lost my train of thought.
Well, basically what I think it comes down
About
to,
how he contradicts the law?
well, people are joining FOP for what, the license plate?
And the Vegas, isn't it Vegas too? Don't they get a trip to Vegas?
Well, they get a trip to Vegas. But it is a constant theme that FOP does not step in and help corrections officers like they're required to. So we're always getting FOP calling us.
We aren't. This is not even a derogatory statement. It is what it is.
It's true.
Yeah, it is true, and it's annoying because I can't help them. At least once a week or twice a week, I get a call from one of their members. Mm-hmm. That's a fact.
I'm with you.
It's ridiculous. I don't get it.
If you want the license plate, that's fine, but you really should consider joining a union that actively works for you, and that is ACCPOA.
You guys just need to be safe and understand when your administrators are telling you to do things that you know are wrong, you push back. You tell them I'm not doing that. We don't have enough staff to do it. It's not a policy. It's not my post orders. Because the minute you get caught in that moment of things they ask you to do and you get in trouble, they're going to send Delgado down there and say that was out of policy and you broke the law.
Absolutely.
So that's the problem with this place.
Yes. If you were given a directive by a supervisor, there are two types of directives. There's lawful directives and there's unlawful directives. If it fits within policy, procedure, post orders, and state law, it is a lawful directive. Whether you like it or not, it's lawful. If it fits outside of it, it is unlawful. If they are trying to force you to do it, have them put it in writing.
Yeah, think about it. Your post orders, I say in the Maury unit, that provides you guys need to have at least 2 floors on that building. Yet you guys are having 1 floor for 2 buildings. Question that. Don't go out there because it's impossible to do security checks at that point and get your job done. So question that. Don't go out there and set yourself up for failure because they're going to hang you when the time comes.
I've done six 601s because they're running out of time to do their, and they're going after them.
I just helped respond to one myself.
Yeah. I want to end this video with a curious thing, all right? We were there. The guy who you just saw in video, this expert witness, what did he do at the end when he was done?
He came directly to Carlos Garcia and wanted to shake his hand.
Oh, he shook my hand. I had no choice.
He tried to bro out with you.
He totally kissed his ass.
He said that he had heard good things about me because he worked with one of my compadres from back in the end, which in the end, back in the time. It's true, I did work with that guy. But for this guy he should have known where the enemy camped. He knew what he did up there was bad. I think what happened is when he realized who was in the audience, he said, holy crap, these guys are going to put me on a tube like we're doing right now. Exactly.
Right.
And we wanted to just say, he came and shook my hand trying to say how great I was. Let me tell you, this is for Delgado because he's going to watch this video because we're sending it. Don't you ever shake my hand. I couldn't get that stink off forever. I did it because there was a camera and I'm just trying to be nice with your honor who's watching us. But the balls that it took for this fella to lie up there on the stand under oath, throw our staff under a bus. He tried. And then even the judge was saying, yeah, I'm not going to have it, and we won. Don't do it again. And you shouldn't be there when we're done here, by the way.
So now that you've seen this, you guys, if you see Delgado, don't give him the respect he's asking
don't trust
for.
him. Why would
Don't
you?
trust him. He's a hired gun for the department, and he'll say whatever
And
needs
then
to be
they'll
said.
have a problem with me because now that this is out here and I'm going to give this to Thornell, that guy should not be anywhere near my staff. I don't want that guy anywhere near me or my staff. He should be gone. So it's a problem. If you see him come back, you gotta, I'm telling you, don't cut, because you guys, I'm saying it, you'll come running to me later saying, Garcia, you were right. Now they're after me for the same thing and they're saying this. I don't want to hear it.
And we
Pay
know
attention.
and we also know that Delgado, when you came in, you suspended the prior curriculum for 1 year.
He did.
No one did self-defense for 1 year
That
because
was
you
right.
said so. Okay? So obviously something was wrong with it, but then you're going to testify with that you know all about it and create a new curriculum that conflicts with state law?
So
Okay.
anybody that used force in that year without training, is he going to go after him?
After this video, I hope not. I don't want to be the think here, but it looks like everyone's going to go down here in a minute. No double locking, illegal takedowns that aren't taught. I don't know what to tell you.
Yep.
I don't know. Apparently, we're not Jedi trained like him where he can, I don't know. There was a part of the video I didn't show, but he shows you how to get into a self-defense move with his little hands up. It's just
He
ridiculous.
said he's a ghost. Maybe he's a Jedi ghost.
Maybe he is a ghost.
Maybe he's in the corner.
Anyway.
And you guys stay tuned here in about 2 weeks. We have some videos coming out.
Yeah, we're going to put more.
Of actual ones that we got from my case. We got 500 of them. This will be a little sample on the news about other takedowns.
And this case, we got to talk about this case.
Correct. About takedowns and restraints, about how prevalent they are,
Yeah.
and how they are authorized. And you guys didn't do anything wrong, yet this man went there and lied about it.
Let's just leave it with this. I got to leave one thing. This case was about 2 whistleblowers in the state of Arizona getting terminated for whistleblowing, and they tried to go on the side and okie dokas, and 4 years later it blew up in their face, and we're not done. This is going to blow up even more.
We're coming.
Okay?
Thank you.
All right, this is the Wolf Daddy saying, till next time, thank you. You know I love you. If you love us back.